rise. Court of Appeals, Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number CV170617, the matter of John Joseph Terrell versus Ruby Torres. These proceedings are being video and audio recorded. So we ask that counsel please identify yourselves and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs and have discussed this case in conference. Counsel, you may proceed.
Thank you, Honor. May it please the court, my name is Stanley David Murray. I'm the attorney for the appellant, Ruby Torres, who was the respondent in the lower court proceedings. I would like to reserve 5 minutes of my time for rebuttal. Well, it's about time a case like this got before the appellate courts and, for that matter, the Arizona legislature. And just as a side matter, I'm sure the court is aware that the legislature has recently passed a bill involving this issue. I'm not arguing that it pertains to this case, though. I just wanted to let you know that we're aware of that, and that I don't know how long or how much import your decision will have based on that statute having been passed now, but it certainly affects the people that are before you.
Given your understanding of that statute and the current circumstances of this case, do you believe that that statute, while isn't dispositive in this matter, will affect what happens in the future for this couple?
For this couple?
Yes.
No, ma'am, I don't think it would. From what I've read of it, it applies to any in vitro fertilization that takes place after July 1st when the statute takes effect. It was signed by Governor Ducey in April, and I believe it's a 90-day waiting period before it takes effect.
When we talk about in vitro fertilization, there is the first part, which is the combination of the genetic material, and then there's the implantation. So if implantation were to occur after the law goes into effect, do you think it will have any bearing on this circumstance?
Well, that's a good question, Your Honor.
Okay, just wanted to, since you brought it up.
Yeah, I would imagine that it's the time the contract is formed, I believe, rather than the actual insemination or the birth either. The way I read that statute, it talks about how, well, actually, it probably depends on when the divorce occurs.
And
That's another
statute
issue.
talks about a child born.
Yes.
Specifically, it says
As a result of
child,
the
and there is
in vitro.
no child in being at this point. So does that affect?
No, there's only property.
Right.
I better save it for another day, I suppose.
Okay. Keep going. Sorry, didn't mean to
That's
divert
all right.
you.
Our position, and I believe Ms. Work agrees with us too, is that the contract is not ambiguous. Judge Steiner found the contract ambiguous because of these various citations that she made to the contract. But if you look at paragraph 10H of this contract, it's pretty clear. In the event of a divorce, the parties checked off the box and they initialed that we want a court to decide the decision to decide the disposition unless we reach an agreement. Well, they didn't reach an agreement, so it's up to the court to decide the issue. And that's when the balancing of interest test applies, which we argue was not applied appropriately. Ms. Work's position is that this note section on a prior page of the agreement says that, oh no, you can't do that unless both parties consent. Well, to read those provisions harmoniously, it's pretty clear that if the parties are in a divorce situation, they would both have to agree before implantation or impregnation could occur. And it seems to me that covers both whether you have the two spouses agree to the implantation or whether a third party is involved, as in a donation. So that particular provision, that note provision, which wasn't signed and wasn't initialed, has no bearing on paragraph 10H, which overrides and says the court is to decide this issue. There's also another paragraph, again.
Can we go over the reasons why the court erred in its application of the balancing test?
I believe the court erred in the way it was reading the various provisions, and that's a matter of interpretation that this court can review de novo. The court emphasized the various contradictions, or at least what she felt were contradictions in the paragraphs, such as the mutual consent provision under that note
So
area.
let's assume for a moment that the contract is valid, it's not ambiguous, and the court, given the provision that allows it to choose between allowing one of the parties to have the embryos versus donating them, the court erred in making that decision. That's your
Yes, ma'am.
That's your position, correct?
Right,
Tell
to
me
balance the
why.
interest. Because my client can't have a child any other way. And the cases that we've cited to you, the other cases from out of state, have generally held that you don't force parentage on somebody unless special circumstances exist. That's the Davis case, the Reber case, the Stravinsky case. And sure enough, in Davis, they would have decided it differently if this was the only way artificial insemination or in vitro fertilization was the only way that woman could have had children. So that's where the court erred in the balancing of the interests.
So then every time one of the parties or the party seeking the embryos cannot have a child any other way, they should be the ones
To get the embryos.
to get the embryos.
Yes, ma'am, that's our position.
Okay.
Okay. Another paragraph that talks about the court being able to decide is on that prior page. Excuse me for a minute while I thumb through it here. It's Trial Exhibit 4, by the way.
I think there's a bait stamp at the bottom of that document, counsel. I don't know if that could help you help us.
Not on my copy, unfortunately,
Okay.
Your Honor. It's on that same page where the note appears, page 13 of 19.
It's number 59.
59. Thank you, Your Honor. Under paragraph 10, it lists 1, 2, 3 paragraphs as the alternatives for disposition of the embryos. But then that next paragraph, the very last sentence says, disposition may also be controlled by the final decision of a court or other governmental authority having jurisdiction. So this mutual consent is not exclusive. The court still can override, and for that reason, we don't think this contract is ambiguous. But even if it is ambiguous, as Judge Steiner felt or found,
And where
there's
did
another.
Judge Feiner in the record say that this specifically was ambiguous? I struggled with finding those words. The court finds this contract to be ambiguous. Doesn't appear in the record.
No, but she does use the word contradictions, I believe.
Yes, on page 14 it says this, the contract in this matter unfortunately is less than clear in that the contract presents some contradictory clauses. I think that's as close as she gets to saying it's ambiguous, but I agree with Judge Campbell. I don't think she's made a specific finding that it was ambiguous, but
That's
maybe
true.
it's 6 one, half dozen the other. I don't know, but I think that's what we're pointing to in terms of her
Yes.
troubled
And
nature
actually-
in terms of the contract.
Actually, Your Honors, it doesn't matter because our position is that the court has to decide the issue. Well, for the court to decide the issue, whether the contract's ambiguous or not, they have to do the balancing of interest test. So we're
Now-
right back to our original argument.
Going back to that, you indicated that because your client cannot have a child any other way, she should get the embryos. End of discussion. But doesn't the balancing of interest test indicate that the courts should consider not only the position of the parties, the significance of the interest, but also the relative burdens that will be imposed by differing resolutions?
Yes, ma'am. And
So
that's-
let's talk about some of those burdens.
Okay, I'd cite you to the Reber case. I believe the Reber case is directly on point with our situation. That court went through the analysis of how the mother went through the strenuous process of preserving her right to have children. It's much easier for the man, I would imagine, in the in vitro fertilization situation than it is for the woman, plus the costs. You also have the fact that she cannot possibly have children any other way. This is her legacy. As compared to the husband's, I wouldn't say father, compared to the husband's interests, he's concerned about support obligations, while my client advised him that she wasn't going to go after him for support. About whether having contact with the child, my client would allow that. Again, all these situations are similarly reduced into the decision in the Reber case.
Well, the first one, the support, is really unenforceable because she can change her mind the next day and seek support and obtain it, right?
Well, that's what the Reber case said, and they said, we'll look to that later. We're not going to be worried about it right now.
Okay. Well,
So
in
that's a
Arizona, if there's a child involved and she can establish that he's the father, she can get child support no matter how, she can say 100 times, I'm not going to ask for child support, and walk out of court at 10 o'clock in the morning and at 11 o'clock go down to the clerk's office and say, I am going to ask for child support. So that really,
Well, I think the husband could prepare for that with a contract between the two of them saying that she would reimburse him if she went after him for support. He could enforce that contract civilly. I'm just throwing
Could
that out
father,
there.
could father 6 months later move for abandonment under Title VIII and get his rights severed?
That's another
And that would
point.
extinguish any type of financial obligation?
Well, it has to be an adoption too, though. And my client said that she would remarry somebody who would agree to support the child, and that, if once he severs his rights, would pave the way for the adoption process.
well, from the record, we don't have anything on the record that says that that's actually in the works right now. I mean,
No, but you have her statements to that effect.
well, depending on
Forcible
finding
as
somebody
it
who wants
might
to
not
marry
be.
her with up to 7
Correct.
children, depending on how things shake out.
Okay, and that's one of the interests to put on his side of the ledger, I agree.
Okay, so let's talk about that. That's what I want to talk about. What are the other interests? Because you said child support, not an issue. You know, she's letting him off the hook on child support. Visiting the children, she will allow visitation, although it sounds like he doesn't want to parent. It's not that he's concerned he won't be able to have access, because he could certainly take her to court and say, I'm the father and I want visitation, but it sounds like he doesn't want to parent. So that's another concern. What are some of the other concerns?
I think he also was concerned about the inheritance, his obligation, or he would lose some money for inheritance. And he was also worried about whether wife would poison the child against him.
Or children? I mean, because really we're talking about 7 embryos.
There's 7 embryos, but we don't know exactly what the success rate would be. But
all 7 could implant or attach.
if she wanted to do all 7, and I suppose that could happen, yes.
Well, I think we should just assume, because she's got the ability to have 7.
Yeah, well, from what I understand, they just do 1 or 2 at a time and see how it goes, rather than all 7 at once.
Do we have a record of that? Don't they usually try to
it's in
implant
one of-
all and then see how many attach and then take off the ones that?
I've read so many cases, Your Honor, and I remember they talked about the procedure in one of those cases. I think it was the Cass case, where it talks about the procedure is 1 or 2 embryos to see if they take, and if they don't, then they'll try another 1 or 2.
Well, but depending on our ruling, either way, she would have access to all 7, so she could do 2 now and 2 later and continue, right?
Yes, ma'am.
Okay, so let's talk about the relative burdens. What about the fact that these children would be, I think the father talked in his brief about she's somehow in relationships with his family. So it's not as though we have a situation where he had donated as an anonymous donor, and now the children are going to be raised somewhere by someone who he doesn't know. I mean, they would be in his circle according to his presentation.
Well, that would happen in any severance situation also. I imagine the families all know each other, and if the father of that particular group had severed his rights and put the child up for adoption when the wife remarried, I would think that same issue could arise.
So what value should we attach to that dynamic? Is that nothing? The fact that a child knows that this man who comes to the birthday parties is my father, but he pretends he's not. I mean, or how do we weigh that?
Very little compared to her inability to have children again any other way. And also that you brought up a point too, he's still going to be the father even if these embryos are anonymously donated. So I don't see the importance
difference?
of that interest when just because you donate them anonymously, you don't sever his rights.
But this is not an anonymous situation.
Well, we have a lot of technology these days, and that 23andMe and those gene things where people can find out who they've been parroted by. I wouldn't be surprised if the kids in the future start doing something like that. So,
Okay, but we're not talking about an anonymous situation here, correct?
well, the judge ordered that they'd be anonymously donated to another couple. That's what her order says.
I
right
mean,
now.
in terms of wife, if she were to
If she were to
the
award
embryos.
them, if she was awarded the embryos, yes, she would want to have them brought to birth.
And that would not be an anonymous situation.
No, but at least father knows he can sever his rights and put up the children for adoption, or mom to do that, so that he doesn't have any of that parental responsibility. And I don't know how close their families are, they travel in the same circles or not, but Maybe somebody will move out of the town or something. They don't have to worry about running into each other. There's a lot of speculation in this case, I agree. It does make it unique. I've only got about 6 minutes left, so real quickly, on the attorney's fees, we believe that the husband took unreasonable positions, and we've listed them in our brief. He wanted the embryos destroyed when the contract clearly said not to destroy them. He wouldn't sign the documents necessary to preserve the embryos post or pre-trial, and my client had to incur attorney's fees to get that order signed. He wouldn't allow the doctor to testify telephonically. He opposed that, so my client had to incur more fees on that, and he wouldn't return the dog. The number of instances where father or husband, sorry, I keep using the word father, husband did not cooperate and required my client to incur additional fees. And in that issue where Judge Steiner felt my client was being unreasonable on the insurance reimbursement, father didn't bring that up, husband didn't bring that up until a week before trial. And she needed to know how much was involved before she was going to pay any money out. So that's hardly an example of her being unreasonable. We ask the court to reverse the decision, and I'll save my time for rebuttal. Thank you very much.
Thank you, counsel.
May it please the court, Claudia Work representing John Terrell. This is actually a very simple issue. The court is required to enforce the clear contract of the parties. As the court has already pointed out, the contract was not ambiguous. The lower court erroneously determined that there were some contradictory provisions in the document, but there are no contradictions in the document. The document is very clear that the parties anticipated that at every step of the way after they were created, that they would either be jointly used by joint permission of the both of them, and that could have been used by only one of them, but with joint consent.
Isn't your argument kind of undermined by the fact that your client testified he didn't read the contract, he simply initialed where she initialed? So did your client really engage in that contemplation?
Well, whether my client engaged fully in that contemplation or not does not mean the contract is invalid. Under Darner and the restatement as adopted by the state of Arizona, this is a contract that the parties knew they were going to have to adhere to. This was not, this was a contract that was regularly used in these types of proceedings. My client was required to initial certain portions of the contract, so he knew what he was initialing, even if he didn't review the entire contract. He initialed portions of the contract that stated that these embryos could not be used without the joint permission of the parties, and he actually did give his permission to wife to use them in the event of his death.
Doesn't that reading of the contract, counsel, vitiate Section H of the contract? Because later on it says a court decree and/or settlement agreement will be presented to the clinic directing use to achieve a pregnancy in one of us or donated to another couple for that purpose. If we're to take your reading of the contract, which is basically Section 10, that first bullet point under the note, I think it reads out of existence Section H.
Your Honor, it does not read out of existence Section H. Section H is there for the protection of the IVF and implantation facility. It's there to protect the clinic. In the event of
what authority do you rely on that? Because right before they start putting their initials on it, it says, please check, this is Bates 60, or page 14 of 19 at the very top. The second bullet point says, please check the appropriate box in each section to delineate your wishes and initial the bottom of each page. And I looked up the Webster's definition of delineate, and that is to describe, portray, or set forth with accuracy or in detail. So this is their delineation of their wishes of how the matter should be resolved. And the way I read Section H, that is their wishes, their delineation is that a court would issue a decree that would direct the clinic to achieve a pregnancy in one or donation to another couple. So I think my reading of the contract, unless you can present arguments and persuade me otherwise, is that this is a more specific portion of the contract that they delineated their wishes, and their wishes is that the court decided.
Your Honor, this does not specifically state that the court will decide amongst the entire universe of possibilities what will happen to these embryos. In fact, this doesn't even specifically state that in all cases the court will have to make the decision. In any dissolution of a marriage in particular, the court has to make disposition regarding the treatment of the embryos and other property. And that disposition can be simply in putting to writing the agreements of the parties. The agreements of the parties based upon prior agreements they made during the marriage and before the marriage. This simply states that it's noted that there are no options for the parties to check something that says the court will adopt specifically what we stated before, nor are there options. There's an option to state that the court can make whatever decision it wishes to make. This specifically requires that the IVF and fertility clinic be given a court order that tells them that there's going to be no further dispute regarding these embryos, that they know exactly what they can do in disposing of these embryos, whether that is awarding them to wife because the parties have jointly agreed in the context of the dissolution proceedings, or the other court action determining regarding disposition of their property, or because the court has heard an argument, has looked at the choices of the parties, including the decisions of the parties to not use the embryos without joint consent, and has then made a ruling that these embryos will either not be used without joint consent or will be donated or will be destroyed based upon the various selections that the parties made and based upon the clear direction and requirements of this contract. There is no way that these parties could get out of this marriage without entering into a decree or settlement agreement that disposes of these embryos.
The parties weren't married when they entered into this agreement.
Correct.
Do you believe that plays into it?
Well, certainly it plays into it to a certain extent, but it actually doesn't, because this document states dissolution of relationship. The relationship could be a non-marital relationship that is dissolved before the courts. The civil courts regularly dissolve unmarried partners and dispose of their joint property. And in those situations where there's a dispute between the unmarried cohabitants, they do result in a judgment or a stipulated settlement that is run through the court and is a court decree or settlement agreement. This doesn't specifically refer to divorce, otherwise it would not talk about dissolution of relationship as a separate.
So you believe that this contract has an overriding kind of theme that the embryos will either be donated to a third party if there is no mutual consent or destroyed?
Correct.
Okay, how do you rectify that with, if we look on Bates stamp 60 and page 14 of 19, we look at A, discontinuation of IVF treatments. So if the parties discontinue IVF with the clinic, who receives the embryos under their choices?
If the parties had decided to discontinue the IVF process, at that time they had agreed that the wife, well, actually it was the girlfriend, would receive the embryos. But Section A does not apply anymore because the parties completed the IVF process. And I believe that was a problem.
And while that makes sense, the I had to go and look and figure out based on this. The IVF process is not completed until implementation because of the storage, and it contemplates storage, cryogenic storage of the embryos. So I don't think it was discontinued.
No, Your Honor, I believe that that is an error that the court, the trial court made. Additionally, that might be confusion on this court's behalf, but the IVF process is in vitro fertilization. It is very clear. Arizona defines in vitro as outside of the womb.
Agreed.
Fertilization is the process of fertilizing an egg with a sperm outside of the womb. It's the process of creating the embryos.
Okay.
After creation of the embryos, they did not need to be cryopreserved. They could have been immediately implanted.
I agree. But when we talk about discontinuation of IVF treatment, what it's talking about, the embryos should be disposed of in the following manner. So conception has occurred, award to the patient which gives them complete control for any purpose, including implementation. So had she simply taken the embryos out of the clinic and stored them elsewhere, she would have ultimate control over those embryos based on your definition of IVF.
Had she ceased the process,
Okay.
and she said, I do not want to implant, I do not want to go forward with trying to fertilize any more of these eggs and move forward to the cryopreservation process and possible implantation with my boyfriend. At that point, she could have stopped at any time. It would not have been a completed IVF cycle.
Okay, so
Therefore-
IVF is completed upon the combination of genetic material. However, you're saying that it's discontinued. I mean, this is contemplating it being stored, number one. It says, number two, award to the patient which gives complete control for any purpose, including implementation, which means the IVF process is completed by the implementation, donation for research, destruction. This may entail maintaining the embryos in storage. So what it contemplates is taking the genetic material that has been commingled and cannot be uncommingled and awards it solely to the patient. So had she said, I'm going to discontinue with this clinic, I'm going to move him to another clinic, she would have sole control over the embryos, including later implantation. Yes or no?
No. She would only have had that control if she had stated she wanted to terminate with the clinic while the IVF process was still going on. The IVF process ended as soon as all viable eggs were turned into embryos. At that point, if she had chosen to discontinue the IVF treatment, at that point, there would be no longer an IVF process ongoing, which is why the provision that states award to the patient allows her to then take this IVF, these embryos that were created through the now discontinued IVF process, and implant them, because implantation is not part of the IVF process. It is part of the embryo transfer and implantation process. It is a separate process. Additionally, she could have donated them for research or destroyed them. The parties agreed in writing to 3 different procedures, and that was ovarian stimulation, in vitro fertilization, IVF, and embryo transfer. Those are 3 different procedures. IVF ends once all of the eggs that were harvested that are viable for creation of embryos have embryos created out of them. That
Which
was
does
done,
not
and the
make any
parties.
sense when you read it with this provision. Would you agree with me? If IVF is finished at the point of combination of genetic material, then when would you be discontinuing it?
You would
Before it's combined, you don't have an issue. After it's combined and it's complete, we don't need this discontinuation language, do we? Because it's finished. How are you supposed to discontinue it? So why is this language even in there?
The language is in there because the parties could have discontinued it while embryos were being in the process of being created. I mean, they were not all created in one fell swoop. There was a system where the embryos were combined, and additionally, they were then harvested in petri dishes, or however that works. I don't even know exactly, but they were grown to 4, 5, 6 days of development in the petri dish, which is the embryo, which is the in vitro fertilization process. At that point, after the sperm and the egg are combined, and then the cell division process is allowed to take root if it can, there's a waiting period where anytime during that approximately week period of time, the cells at that point, because they're not embryos, are watched to determine if they are developing properly. There
And I
are
get all
certain ones
that.
that are disposed. There are certain ones that are determined they're good.
What
And-
I'm asking is this entire clause that says she gets the eggs for that 7-day period.
Correct.
That's it.
That's it.
That's the way you read it.
That's the way I
Okay,
read it.
That's what I needed to know.
Ms. Work, in reading Judge Steiner's order, she seemed to go through a lot of the case law out there that's in existence, Davis, Zavransky 1 and 2, Reber, and she seems to track the analysis that those courts have went through up to a point, and then where Davis, Zavransky, even Reber talks about that it goes to the fertilized eggs go to the parent that does not want to be made a parent unless there's a reasonable possibility, unless the other parent, soon-to-be parent, does not have a reasonable possibility of achieving parenthood by other means. It seems like Judge Steiner, when she gets to that, she gives that short shrift. And I know that's Mr. Murray's argument, and that's what I'm struggling with. So how did she not err in the very limited circumstances, the circumstances in which I believe we have here, where mother or wife cannot get, or very slim chance of being impregnated without this procedure? Why doesn't that very extreme circumstance that Davis, Zavransky, and Reber talk about, how come that doesn't apply here?
Well, first of all, this is not an extreme circumstance. Davis specifically states that the balancing test would tip if there is no other way for one of the parties to obtain parenthood. It does not talk about genetic parentage. And frankly, anybody who has adopted a child or has raised and parented a non-genetic child knows that parenthood and genetic parenthood are two different things. I mean, somebody can be a parent without being genetically related to their child. It happens all the time. In Reber, first of all, the parties did not have a contract. The parties had not contracted as to what would happen if, upon death or dissolution of their marriage. Additionally, in Reber, the wife in that case was of a much more advanced age than Ms. Torres in this matter. Ms. Torres, at least as far as when I got involved, was 36 years old, so she's somewhere around 36 years old. She cannot say with certainty that she will not start creating eggs on her own, nor does her age place her out of the range of ability to have donated eggs, donated embryos. There are, in the ART, the assisted reproductive technology process, there's the ability to have embryos donated by family members, eggs donated by family members, so that she could achieve her goal of genetic parentage, because she states that she has the ability to carry a child. She just needs to obtain eggs or embryos. There is a market for embryos and eggs. There is a very frequent occurrence where family members will step forward and offer embryos or eggs, because certainly on the embryo situation, anybody who's gone through the IVF and embryo implantation or cryopreservation process, they typically have excess embryos, because the goal is to produce as many as possible, at least 10 or 15, to ensure that at least a couple of them will be viable. So a lot of couples have their children and they still have eggs, embryos on ice, so to speak. And those are up for either donation through the clinic or donation through private parties.
But her carrying a child, didn't Dr. Beharra said that it's less than a 1% chance of her, since she's in postmenopausal state, to have a child herself?
Not to have a child herself, it's to produce viable eggs, but she cannot say whether or not she's going to be able to produce viable eggs. I don't know if the court is aware of the Rooks case in Colorado, but in the Rooks matter, the wife in that case also underwent cancer procedures, and when that matter started, the court, she avowed to the court that she would not be able to produce her own eggs. She would not be able to carry a pregnancy. From between the time that case was settled in the trial court and the oral argument with the Supreme Court, that woman had become pregnant again and given birth to another child, not using those embryos. Now, the court didn't have any answers as to how that had occurred because the fact-finding had ended by that point. But it does happen. This is very close to the procedures for Ms. Torres, so she could start spontaneously producing viable eggs. Additionally, she can go to female relatives and ask them to donate eggs. She can combine that with sperm of a future husband if that person wishes to become a legal parent.
Wasn't the entire purpose of entering into the IVF process the fact that Ms. Torres was diagnosed, had 1 month to decide what she was going to do about her fertility, and started investigating potential donors? I believe your client said no. She found an alternate donor, and then your client acquiesced and agreed. Am I missing something there? The whole purpose seems to have been for Ms. Torres to preserve her fertility with her eggs and her genetic material.
And that may have been how these embryos initiated, but the parties entered into a contract and an agreement that was set down in writing that is enforceable that took away the control from Ms. Torres.
So if we find this contract to be ambiguous, then we rely on parole evidence to ascertain the true meaning of the parties. Would you agree?
The court could in theory, but I believe based upon the existing case law in the rest of the country, if the court adopts the Davis test, the court then has to just get into a balancing test.
Okay.
And at which point the court can weigh the intentions of the parties before they entered into the contract, certainly.
Okay. But you agree we're not bound by Davis?
Correct. This is a case of first impression in Arizona.
If we were to engage in a pure contract analysis, putting this outside of embryos and eggs and just looking at the contract, and we say the contract is ambiguous, how would you ask the court to approach this issue?
As far as the balancing of interest tests?
Let's say we're not bound by the balancing of interest test because we're not. How would you suggest we approach this? From a pure contract point of view, replace embryos with dishes. How do we do that?
Your Honor, my client no longer wishes to own dishes with, and that's kind of nonsensical, with his ex-spouse. And the fact that the dishes, which have great sentimental value, great psychological value, will be placed in the possession of the ex-spouse to do whatever she wishes with them, will cause psychological, emotional harm to my client in the future.
Don't we do that in divorces all the time? But back to contracts. The contract is ambiguous. Here's the intention of the parties. Here is the outcome based on that. Let's talk about promissory estoppel. What do we think about that?
Promissory estoppel does not exist where the parties entered into a contract where they had the opportunity to review. I mean, Ms. Torres had the opportunity to review the contract, and it's undisputed that she read every portion of this document. She initialed every page, including every page and that stated numerous times, page 13, that these embryos could not be used without the joint consent of the parties. So she cannot invoke promissory estoppel against the husband when she knows she was not relying on his promises prior to the contract. She was relying on the contract. She's asked.
Didn't the trial court say the contract was, what was the words, Judge Beam? The contract was unclear. While she didn't say the contract was ambiguous, you could infer she did. So if we say the contract is ambiguous, then what?
Then I believe the court needs to balance the interests.
So adopt the Davis test, not contract principles.
At that point, the court needs to balance the interests because these are not dishes. These are pieces of property that have special weight. The court has already designated that these are not dishes. These are somewhere between dishes and children, but they are not children either. So the court needs to balance the interest of the parties in becoming their constitutional right in becoming a parent against the constitutional right not to become a parent against one party's wishes. No. I mean, at the moment that this court awards the embryos to Ms. Torres, the constitutional right of my client not to become a parent is forever extinguished. If the court orders these embryos donated or destroyed, which the court has the authority to do under the contract, then wife still retains the right to parenthood, and she has many options to do so, just not with husband, ex-husband at this point.
Thank you, counsel.
Thank you.
Just taking the arguments that were made in somewhat in the order that they were presented, Judge Bean had asked about Section 10H of the agreement, which talks about disposition of the embryos by court order. Again, I want to emphasize there's another part of the contract as well, and that's the prior pages where paragraph 10 begins, and I don't have the Bates number, but page 13. Again, the document says, disposition may also be controlled by the final decision of a court or other governmental authority having jurisdiction. So we have two areas there that seem to emphasize the court has the authority to make this decision regardless of mutual consent. But Judge Campbell brought up a point that I didn't address in my opening. Paragraph A on page 14 talks about the discontinuance of the IVF's treatment. I don't think the parties knew there was any distinction between the fertilization process and the implantation process. They had a contract with the Bloom Reproductive Company, I can't remember the full name, and they understood that they were going to not only cause the fertilization, but also cause the implantation. If they had stayed married, I'm sure the process would have been completed, and no separate cutoff was listed either in the contract or in their understanding. The cases have held consistently that inability to have a child by other means weighs heavily in favor of that spouse. The bio child is very important under the Reber case. Talks about all these other suggestions that Ms. Work had are not the same as having your own biological child, especially when you go through the process of IVF treatment,
Why
not to
is
mention
that?
chemotherapy.
Why is that? Why is it different to have a biological child?
Something to do with bonding between a mother and child, I suppose. Something in our history, our growth, our development, our culture. Adoption.
That says what?
That says it's important for a woman to be able to birth her own child. We talked about how adoption and all these other alternatives wouldn't work for my client. She testified about she'd be on a long waiting list because of her cancer. It would be easier for her to have her own biological child as a result.
Well, and when we're talking about the bond, biological bonds, we're not talking only about the woman being able to have a child, but just the birthing experience alone, but everything else that comes with being biologically connected to someone, correct?
Yes, ma'am.
And so wouldn't that also, the other side of the coin is what that implicates for the potential father in this case?
Yes, there's competing.
And the bonds that exist, even whether he pays or doesn't pay child support or has some financial obligation?
But he still has the option of severing those rights. And the thing that really bothers me in the first place is why would he volunteer in the first place? He would have known that eventually the child was going to be born. That's the whole purpose of the IVF process.
Well, why did he volunteer to marry her in the first place, right? He didn't have to do that either.
Well, he said he did it as a favor, so perform
there
a
was
favor.
We have to admit that there was a relationship between these two people. It's not, I mean, was it really fair to say, why would he volunteer to do it in the first place? Well, there was a relationship and he cared for her.
Maybe I'm going a little too far with this example, but it seems to me that if the married couple had sex, let's say 8 months before they filed for divorce, and all of a sudden the father said, I don't want to have this child anymore.
But it's very different, isn't it?
Well,
because you have...
he's changed his mind after the event has occurred that everybody has relied upon.
Well,
I don't know if promissory estoppel is the right word.
But in this case, she signed a document that said, that gave the opportunity for that process to be stopped, which is very different from a pregnancy and the natural way, right? I mean,
Yes.
when the couple has sex, nobody can tell her, you know what? I mean, she knows, absent some medical condition, it will result in a child. This is different because there's the cryogenic option, the freezing option, right?
Yes.
I mean, that's a big difference,
Okay.
right? I mean,
Yes.
we're here, how many months after the embryos were produced, talking about it.
But again, Reaver points out that he had that option and that he knew that eventually a child would be born. They didn't put much weight on that interest that he decided to change his mind. And that's my argument.
All right.
My time's just about up. If there's any other questions? Thank you, Your Honors.
All right. Thank you, counsel. The matter is now taken under advisement, and a written order shall issue in due course.
Thank you.